Beacon County Court of Common Pleas is again in session. The Honorable Christine Croce presiding.
Thank you. You may be seated. All right, Mr. LoPrinzi, you may proceed.
Thank you, Judge. So it's not lost on me that when you knew I had to get up and do rebuttal, that I didn't hear the mental sigh from the room. I get it. You've been doing this case for over a month. You've heard things over and over and over again. I understand that. I appreciate that. I will try and keep this as brief as possible. However, I think that Mr. Gorman's pointed out, you understand the importance of this case, and that I have a duty to the citizens of Summit County. And so, I always kind of harken back to the thought, and I often say when, I graduated from law school, my big dream was to get up in a case such as this and do a closing argument and really change your minds and convince you of the guilt of the defendant. But as I've gotten older, I realize that's not the goal. The goal is really that I waste your time and bore you for the next so many minutes because the evidence spoke so strongly to you that you didn't need me. The problem is I can't ask each one of you at this moment, okay, so how are you on this? How are you on that? What do you think about this? What do you think about that? And so I feel like I have to get up and at least try and make my arguments to you in response to Mr. Gorman's arguments, just in case. And even if I say something that you might think, okay, I get it, you're beating a dead horse, the person next to you may not. And so it might help them just a little bit. So please bear with me as I know I'm the last to go, and I really do understand that, but I do think it's important. Mr. Gorman, I know, ended on a very emotional thought, which he talked to you about Audrey Taylor and what she said. He spent a lot of time, actually. He didn't just spend that 1 second and say, she said, I don't think he can do it. He did it. Now, we all know that's completely irrelevant in this case, right? What Audrey Taylor thinks of whether Mr. Ford did it or not is absolutely irrelevant. Just as irrelevant as when I asked Detective Looney, what do you think? Do you think he did it? Or if I asked any other witness, it's completely irrelevant. It's nice, it's good to close on, it's emotional. But there's other people in that neighborhood who walk up and down those streets we can't ask, and we all know that. And that's why it does not matter. It's irrelevant what Lindell would think, or Gloria would think, or Dennis, or Angela. It doesn't matter. Not here. Not today. So it's my job now to kind of respond to what he said. He spent an hour and a half. I'm going to tell you, I'm not going to spend an hour and a half re-arguing every point he made. I'm going to ask if there's something that he said that I don't respond to, but you're maybe thinking about, that you use your common sense, rely back on the evidence, and use that to figure that out for yourself. We believe, the state believes, that if you use your common sense and reason, you will ultimately be firmly convinced that Stanley Ford killed 9 of our citizens. One of the things that I think is interesting is that Mr. Gorman, throughout his closing argument, used the phrase, "it doesn't make any sense." Why would somebody take the shoelaces out of the shoes that they got thrown into the trash? Well, ladies and gentlemen, as you can tell in this case, just starting from the whole reason we're here, does it make sense to torch a house with a family of 7, including a 1-year-old baby? Does that make sense? Under what circumstance in our world does that make any sense? It doesn't make sense. And so what the person who does that, what they do may not make sense either. So just because there's certain things that Mr. Ford did that we don't understand doesn't mean he didn't do it. Because what we do know is that killing 9 people, 5 of them children, doesn't make sense. So that should not excuse or explain away that he didn't do this. One of the other things that is kind of interesting is that Mr. Gorman spent, I would say, probably 75% of his argument on alternate suspects. And I get it. I get it. You can only argue with what you have. And the fact is that there are a lot of alternate suspects. There are a lot of motives. I'm not going to tell you that the witnesses you have, if you're, in hell, that's who you have. You have devils for whatever you said. I don't even know because I never use it. But the fact is that in this case, we have a situation where Mr. Ford felt like he was an angel. He told people that. And Mr. Gorman kept using, well, Mr. Ford said this, and so therefore he said, he corroborated the fact that there was a black car, things of that nature. And he would rely on Mr. Ford's statements when he made his arguments to him. And it was interesting because in Mr. Ford's statements, he said opposite things all the time. You didn't see me coming in the house, I was asleep. Okay, I was coming in the house because if somebody was coming in the house, it was me. Right? He says, I use my red wing boots to cut my lawn until he hears that they found some sneakers. Oh, what type of sneakers? Oh, New Balance. Oh, yeah, I cut the lawn in New Balance, which, by the way, Mr. Gorman brought out for you. I'm not going to bring them out again, but if you look at them, there's no grass on them. So Mr. Ford seems to deflect, as Detective Looney's told you. And in his deflection, you can see his attempts to avoid. And in this case, even in the closing arguments, the defense's deflection is to avoid. Because even in that, Detective Looney is really smart, but he's incompetent. It's always whatever suits their need at the moment. The evidence in this case isn't like that. You will never hear us suit our needs by the moment. It is the evidence. And the witnesses with their foibles are the witnesses, and nobody's explaining them. Nobody is saying that there is something they are not, or that they didn't say what they didn't say, or that they did say what they did say. The fact is it's the evidence that we rely on. So he spent 75% of his time on our alternative suspects. And I guess I would too, because they got a lot of motive, right? I mean, let's all be honest. We've said that from the straight. Boggs. He would be a prime suspect. Spouse, significant other, always a prime suspect, right? They talk about the pressure to arrest. There's such pressure to arrest. Why didn't they arrest him? 4 days afterwards, he supposedly gave a confession. Is it because they're so incompetent that they had a confession from a guy who had a history with this woman that they wouldn't arrest with such pressure? Or was it because they're not incompetent? And it's because they looked at the evidence and made hard decisions about the evidence and who it is that did this crime. Mr. Gorman and his voir dire talked to you a lot about the elements. He wanted to make sure you all understood that if we missed one element of any of the charges, it's a not guilty, and he's right. But you know it's not an element? Motive. So what he has done is, for 75% of his argument, talked about motive. So all these people that he's talking about have motive, but not one lick of evidence, not one little bit of evidence that any one of those people committed this crime. Macklemore, Ronald, I can't even list them all, Francine Lewis, any of them. The only thing they had is motive. They talk about, oh, he was seen there 2 days before, or this person had lied because he had been there. That doesn't put them there the night of this crime. So I'm going to try and make this a little bit easy for you. I'm going to suggest this to you. You saw the video. And in that video of May 15th, 2017, In that video, we're going to go backwards. We're going to deconstruct this. Reverse engineering. On that video, you see on the porch of Chester Williams a flash. That's the accelerant igniting on the third attempt. 693 volts. I think it's pretty clear that that is when the house is set on fire and it catches. 20 seconds later, after we see that flash, we see an individual running up the street. If you are not in a situation where you go back in the jury room and you aren't firmly convinced that that is the person who set that fire, then I'm done. I'm done. Because I'll never convince you anything else. If you believe and firmly are convinced when you go back here that the person running up the street 20 seconds after the fire is started is the person, then all we have to do is figure out who that person is. That's it. And that's what Detective Looney told you. He told you he was convinced of that. And therefore his investigation focused on that. And what he did was he focused on the person going up the street. And if you look at that same person, where does that person go? They go to 1374 Hills. And they appear to go into the house. And the alarm codes are going off and being set. And then minutes later, you see a person coming from that house, out of the house, walking next door to what address? 1370 Hillcrest. And if you were the detective in this case, what would you say? You'd say, hey, all we have to do is find out who is in that house. And the case would be solved. Regardless of whether Mr. Boggs tried to set Angela on fire before, what difference does it make if we watch the guy who set the fire go into the house? Because it's who's in that house. And this is where Mr. Gorman's reliance on his client's statement comes in, because who does he say is in that house? Nobody but him and his wife. And if you look at the videos, I don't think anybody here is suggesting his wife did this. So all the noise that we heard about all the other suspects and all the other drug people and all these other things is just noise. Because we know, again, if the person running up the street is the person that set the fire, then you just have to figure out who's in that house. And that's where your common sense and reason comes in. Just like you can contort your mind and do mental gymnastics all day long to say, well, listen, you could be somewhere without your phone. Use your common sense. When was the last time you were somewhere miles and miles away without your phone? People don't do that. That's the ordinary common sense stuff. It does happen. I've left my phone at home, right? But here's the situation. Would it happen to be that Mr. Boggs left his phone at home while Mr. Ford is out and about doing all the things that he says he was doing, getting lemon balm and moving TVs, although he says that the TV was moved way, way before? It doesn't make any sense. And Mr. D'Angelo, I think, did a great job of telling you and explaining to you possible versus reasonable. Reasonable. Who is in that house? The only people in my house are me and my wife. Who has the key code? Me and my wife. Nobody else that I know. Who has keys to the house? Me and my wife. Not Stanley Mitchell. He's a convenient person because he's related to him, and they could make you or suggest to you somehow that maybe he's protecting his son, but we know that his son doesn't look anything like him. He's 130 pounds, 6 foot tall. And anybody who watched that video can tell that the person running is not 130 pounds and 6 foot tall. It's a husky individual. And that's why we said if he is involved, it's only because his father did it. And now they want to come and say, well, we know somebody did the alarms because he was in custody. Well, we all know that he told his wife and his son to go do it. He didn't say that they didn't have the code. His wife has the code. She could have given it to the son, but somehow that's now evidence that his son may have done this. Common sense and reason. Do not do mental gymnastics to try and fit an unlikely circumstance into their argument. The fact is who lives in that house, who has access to the house, and the only person that fits the build, shape, and access is Mr. Ford. That's why we also do the side-by-sides. So you for yourself, as you know, not one person took that stand. We didn't ask one person on this stand their opinion about who did this crime, who was in the videos. Not once. Because you know why? As Detective Mooney said, I'm not the finder of fact, you guys are. And he's absolutely right. He's absolutely right. And so that's why we give you the tools and the information you need to be able to determine if Mr. Ford is the man running from that fire. So that talks about the fire. I told you we're going to deconstruct it. And I'm not going to go into a huge amount of more detail, but the fact is if you work backwards then, what are the commonalities? Detective Tanisha Stewart is incompetent as Mr. Gorman wants to say she is. And she might not have been your favorite witness, but the fact is she said one of the most important things, and that's commonality. What's the commonality that's lacking in all the other suspects? There's nothing to tie the three of them together, yet we know the two in the video, clearly the same person. You can see it. You can see how they walk. You can see what they're wearing. Same person. It's the commonality. Same going to the house. Same using the panel code. They want to tell you that the alarm codes are often used during the nighttime. Well, I looked at them. You'll have it. And you will see that there's only about 9 times that the alarm code is used in the middle of the night. 9. 3 of those were the nights of the fire. That's over about an 18-month period. That's pretty good odds. As a matter of fact, those are such good odds, I would think maybe we should go look for other fires those nights. But the fact is that it is not as much as they want to say, oh, he's always over there. He's always doing this. And again, of course, they want to admit, oh, he's there doing it, but at the same time, well, he wasn't doing it that night. You can't have it both ways. Things like in their arguments, and I hope these are the things you're picking up on. The dog hit on Boggs' socks, not his shoes. Why would we test his shoes if there's no hit? We test on the things we find. We don't waste time. We don't have time to do wasted testing. Mr. Gorman puts us on, puts the burden on us, which absolutely is beyond a reasonable doubt. It's firmly convinced of the truth of the matter asserted and that he is the one that committed the crime. That's what we have to do. And he is right, it is used in traffic offenses. It is a reachable burden. But it's interesting how when he was arguing, and Tanisha Stewart, of course, the judge will tell you this is your memories. Tanisha Stewart didn't say anything about suspension that I recall, and of course it's your memory. What she said was, I thought it was a truck because the lights were higher and the length of it was longer. I thought it was a truck, but I don't know. That's what I recall, she said. But somehow it's all of a sudden that, she said about suspension and it's a truck and it's absolute. And then what did Mr. Gorman tell you? That the person who set the fire in the first 719 Fultz fire went and got in that truck. There was no evidence of that. Tanisha Stewart thought that might have happened, and she put that in a report originally, until we got the videos and saw the movement between the houses and around the houses on the side of 1374. And she told you, look, after I found all this out, after I saw the alarm stuff, after we figured this all out, hey, things changed. Which, by the way, let's not fault Tanisha Stewart for not succumbing to the pressures to arrest, right? I mean, that's what they're saying. All this pressure, and they focus on just Mr. Ford. Well, that's not true. They focused on Mr. Boggs first. They actually arrested him. Tanisha Stewart felt she didn't have enough, and she didn't do it, and somehow that makes her incompetent. We get additional evidence. Detective Looney's now on the case, and together, and with others, they realize there's a lot more. If you believe, again, the person going up the street 20 seconds after the fire at 693 Fultz is the person who set the fire, and you see that person going into the house, and we know who's in the house, we know who has access to the house, and it's Stanley Ford, and he tells us that. With that information and that MO, it's not hard to look at the 719 Fultz case and make the same comparisons based on the commonalities of the two. They're wearing the same type outfit. They go to the place 3 times. Now maybe that's just because he couldn't get it set. But the fact is he goes there 3 times. And each time he runs back toward his house. Commonality. Alarm codes. Now in that situation, you will see in the alarm code that he does not come out. He goes into the house, and the alarm's not set until 6:03 in the morning. Keeping in mind, his wife gets up and leaves to go to school at 6:30. So at 6:03, he sets the alarm to that house again. You heard the evidence about the January 23rd fire. And in that situation, again, what do we hear? We hear Mr. Ford, number 1, is told by Miss Ewing that a car, either her driveway's windows were knocked out. She talks to him about it, and he says what? I think Anthony did it. What happens then? Shortly after that, Anthony's truck ends up being on fire. Also happens to be that Anthony is with Nyjah Sands, whose son also had an issue with Mr. Ford. And so the truck that belonged to them ends up on fire. And what do we know? 3 minutes, 4 minutes before that fire is reported, Mr. Ford is hitting his alarm. Commonality. Let me go back to one other point. Mr. Ford, that's right, in the 719 Fultz fire, we saw, you can actually see it. It's eerie. You can see the man with his back slightly turned to the camera, putting the lighter fluid on the side of the house. He lights it. It doesn't go. We heard testimony that lighter fluid is a medium petroleum distillate. Right? And that's what they find on the side of the house. I think it was numbers 1 and 10. The person leaves, the fire goes out. You will then actually see the person over in the other house, his mother's house, looking around the side of the house, looking out the front door as though during this time period the seat didn't start. And then he goes back and another 3rd attempt, he actually lights the porch. And what do we find on the porch? Gasoline. Not a medium petroleum distillate. So what does that tell us? That tells us that maybe the person who set this fire had access to multiple methods or accelerants, such as his mother's house. Where if you look at the photographs of the search warrant of his mother's house, it's like a shed. It's got gas, it's got lighter fluid, it's got everything you need. I would think that if Mr. Boggs drove all the way from Ravenna or Portage County, that he wasn't bringing several different types of accelerant to start this fire. It was somebody that failed twice and said, you know, that didn't work. Maybe I should change it up. I'll use gas this time. He used his mother's house as a home base. And that's where he did all 3 fires. Coming and going from that house to his house to the fires. If you also notice, and I know Mr. Gorman, I don't know if he meant it or not. The fact is that Mr. Ford, this is the transcript of his statements. You can imagine that there's a lot in here that's just talk, that's not relevant. And so we give you what we felt was the important parts of that. So please don't, just because he says, you're only going to get to here, you can't use that evidence as evidence. Just like if I got him and says, we're only giving you 15 minutes, but I wish you could hear the rest. That would be improper, right? Because I'm implying something to you that may not be or may be true. There's many reasons why you may not hear the rest of that statement. The fact is you have to ignore that. And I said in voir dire, you can only decide a case on what evidence you have. If we didn't bring you the evidence and you don't have it, then you don't have it and we don't get the benefit of it. The evidence we bring you is what you have to make the decision in this case. And it's the state's position that this is more than enough to get you to firmly believe that the defendant committed these crimes. And please, I apologize, I'm skipping around trying to make sure that I cover all the different things I want to respond to Mr. Gorman. So, ladies and gentlemen, one of the other things that Mr. Gorman talked about in that interview is he really pointed out Mr. Ford versus Detective Looney and somehow suggested that his client wasn't very bright. We don't know that. You don't know that. Obviously, Detective Looney, he testified about what his educational background is, and it's obviously highly educated. Just because a person isn't educated, and we don't know what Mr. Ford's education level is, and that, I'm not here to argue that. The point is you don't have to be educated to be smart. And the fact is that Mr. Ford actually was kind of smart. Because what he was doing initially was deny everything, gather information. If you listen to the interview, especially the very first ones, he is trying to gather information from the detective so that he then can respond, just like with the sneakers. What do you use? My Red Wings. What'd you take? Sneakers. What type? New Balance. Oh, I cut in New Balance. And he's adjusting his arguments. You did not see me coming out of my house because I was asleep. I have evidence of you coming out of your house. Oh, well, if I was getting lemon balm. And he would adjust and adapt throughout the interviews. The one thing he couldn't do, though, and you will see it in the interview, and quite frankly, I'm not sure why. And again, I don't know why what he does doesn't make sense. He has been told, and Mr. Gorman put this out there clear, like it was a bad thing, that they got him in that room, chained him to the table, and told him, you've been charged with 9 counts of aggravated murder. All we need you, Mr. Ford, to do is tell us why you were down the street. And he couldn't. The most simple of all questions. And if he was innocent of setting that fire, and he wasn't the man who ran 20 seconds after that accelerant exploded, if it wasn't him, why isn't he telling us why he was down there? And initially, you know, when I was thinking about it, I was like, man, maybe he has an affair. Maybe he was getting drugs. They gave him the opportunity to say that. And he said no. And then you might say, well, heck, you know, he still didn't want to, you know, he's still married. Who in the face of 9 aggravated murder charges doesn't tell you, hey, listen, I was having an affair with a lady down the street. I was hooked on drugs. I was gambling. Whatever it is. Instead, Stanley, make sense of this. Tell us why you were down the street. Can I go down the street? Is that the response of an innocent man? It is not. Ladies and gentlemen, I just want to double check my notes here. One of the things, and I will tell you, maybe prophetic, maybe Mr. Ford should have listened more, I don't know. But in his interview with Tanisha Stewart, the very first time he meets, I think she's with Sergeant Lee in 2016, after the 719 folks. In his conversation, they're talking to him about, hey, listen, your name came up because of your relationship with the people over here that died. And they talk about that relationship, and Mr. D'Angelo went over the statements he made about them being bad people. But one of the things that kind of gets glossed over in his statement is that he says at 3:16, 3 minutes and 16 seconds in his interview, he says, my wife always encourages me to not even bother them because they are bad people and God will take care of them. That was an interesting statement that he made to the police that day. In light of the statements he's made to other people about him being an angel sent by God to watch over his neighborhood. At 10 minutes and 30 seconds, he says, my wife says, the devil is busy. It's real easy to get caught up, and once you get caught up, you get caught up. And ladies and gentlemen, I'm not sure why his wife is telling him that in regards to his neighbors, the ones that he was having problems with. But maybe she foresaw what was in him and was warning him to stay away and let them be. But he couldn't. Just like he couldn't stop talking, he couldn't listen to his wife, and instead of getting caught up, he got caught. And here we are today. And ladies and gentlemen, I'm just asking you, on behalf of the state of Ohio, I ask you to, this is a big case, serious case, obviously we know that, and we would expect you to look at every piece of evidence, look at every video, whatever it takes to give the defendant every single benefit of the doubt by looking at everything. But use your common sense. Test it. And when you do, at the end of the day, you will find that the man, and be firmly convinced that the man that's running from that flash, that runs to 1374, then to 1370, is none other than Stanley Ford, by his own words. And we would ask at that point in time, did you find him guilty of all the charges? Thank you.
Thank you, Mr. LoPrinzi. All right, ladies and gentlemen, we're now on page 67 of the jury instructions, if you want to follow along. You have now heard closing arguments. The charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your findings as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of any one or all of the offenses charged. Evidence was received about the commission of 3 separate fires and the charges associated with each fire with which the defendant is charged in this trial. That evidence was received as to each specific offense or offenses charged relating to each separate fire. The evidence was not received, and you may not consider it, to prove the character of the defendant in order to show that he acted in accordance with that character. If you find that the evidence of one of the fires is true and the defendant committed that fire and the offense is associated with that fire, you may consider that evidence as it relates to the remaining fires only for the purpose of determining whether such evidence proves the defendant's motive, plan, and/or identity. We call this other acts evidence. Motive. You can consider evidence of one fire that shows motive or that establishes that the defendant had a specific reason to commit the other fires charged in this case. Plan. You may also consider the evidence of one fire to determine whether it is linked to the other fires because the acts carried out in the furtherance of the same overall plan. Evidence of a plan or common design refers to a larger criminal scheme of which the crimes charged is only a portion. You may consider evidence of a plan if it supports the identity of the person who committed the act. Identity. You may consider the evidence of one fire to determine whether such evidence proves the defendant's identity. You may also consider the evidence of modus operandi to determine whether the evidence proves identity. Modus operandi means method of working. It is evidence of a signature, finger-like characteristics, unique enough to show that the acts in each fire were committed by the same person. Other acts evidence cannot be considered for any other purpose. Words and phrases. Words and phrases shall be read in context and construed according to the rules of grammar and common usage. As to any definition which contains the name of a specific victim, you shall substitute the name of the specific victim for each corresponding count. In your deliberations, you may not discuss or consider the subject of punishment. In this phase of the trial, your duty is confined to the determination of whether the defendant is guilty or not guilty of some or all of the crimes charged. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all the disputed questions of fact, to apply the instructions of the court to your finding, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all of the evidence. Make your findings with intelligence and impartiality, without bias, sympathy, or prejudice, so that the state of Ohio and the defendant will feel that their case was fully and impartially tried. If during the course of the trial the court said or did anything that you consider an indication of the court's view, you are instructed to disregard it. Now, your initial conduct upon entering the jury room is important. It is not wise to immediately express a certain determination or to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position even if you decide you are wrong. Consult with one another. Consider each other's views and deliberate with the objective of reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide the case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced it is wrong. However, you should not surrender an honest conviction in order to be congenial or to reach a verdict solely because of the opinion of the other jurors. If during your deliberations you have a question regarding the evidence or the instruction of law, it will be necessary that you prepare your question in a brief written form. The bailiff will deliver your message to me, and either a response will be sent to you or you will be returned to the courtroom for further instruction. As I had previously instructed you, no juror was required to take notes. The taking of notes was entirely a matter of personal preference for each juror. The fact that notes taken by a juror support his or her recollection in no way makes his or her memory more reliable than that of jurors who did not take notes. One of your first tasks upon entering the jury room for deliberation is to elect a foreperson. The foreperson will see that your discussions are orderly and that each juror has an opportunity to express their views, discuss the case, and to cast his or her vote. Otherwise, the foreperson's responsibility or authority is the same as any other juror. The court will place in your possession exhibits admitted into evidence in the verdict forms. The foreperson will retain possession of these records, including the verdict forms, and return them to the courtroom. Until your verdict is announced in open court, you are not to disclose to anyone else the status of your deliberation or the nature of your verdict. This order must be strictly obeyed. The verdict forms will be in this envelope or this folder, and you'll be given them. Each one of them has a verdict number on them, and then in parentheses under it is the victim's name. And that's really for you for purposes of just keeping them organized, and so that you can refer back then if you need to the jury instructions and what count that is. There's a place for you all to sign your name next to your number. That's the number that you're currently sitting in, not any of your old numbers. They also need to be dated on the date that you sign the verdict. Now there's additional instructions at the bottom of the verdicts for the charges, which will instruct you on whether or not you're to consider the specifications. And it'll indicate to you, for example, in verdict form number 1, if your verdict is guilty to aggravated murder on count 1, you must complete the following verdict forms for the aggravated murder specification to count 1. If your verdict is not guilty to count 1, you will leave blank the verdict forms for the aggravated murder specifications to count 1. And then it's the same thing for specification 2 to count 1 and all of those. So there's varying instructions as to each count. They're pretty self-explanatory, but you'll only proceed if you find him guilty of one of the underlying charges before you consider those specifications. If it's not guilty, you will not consider those specifications. If you have any questions about those, you can put those in writing and we'll do our best to answer. I want to talk to you a little bit about questions. I will not answer for you what someone testified to. That's your job to rely on your collective memories as to the testimony. We will not read back portions of the transcript because, again, it's your duty to rely on your collective memories as to what the evidence will be. So those are some questions we usually get, and those are ones I will answer. I mean, I'll answer you until you know, but I'm not going to do what you're asking me to do, and that's typical. And so I just kind of wanted to give you a heads up. You have to talk amongst yourselves and remember together what that evidence is. So we're back to the documents now on page 71. Should you wish to take a break, you may do so at any time. However, you must summons the bailiff so that you can be released to take your break. When it is concluded, the bailiff must be notified it is concluded so that the bailiff knows you have started your deliberations again. During any breaks during deliberations, any documents related to the status of your decision must be safeguarded and secured so as not to disclose the status of your deliberations. All of your deliberations shall be held in the jury room. You must not discuss the case with any of your fellow jurors while on any break or outside the jury room. You may only deliberate when all 12 are present in the jury room. After all, and I repeat, all 12 jurors agree upon a verdict regarding the counts and specifications in the indictment, fill out the verdict form or forms that correspond to your decision. Each juror must sign each verdict form in ink by the number that corresponds to your current juror number. Date the verdict form on the date it is signed by all 12 jurors. When you have reached a verdict as to each count and specification, notify the bailiff. You will then be returned to the courtroom and your verdict will be announced. You will be sequestered during your deliberations in the trial phase of this case and if required overnight. I provided each of you a sequestration admonition, which I have filed and which explains the sequestration process. It is impossible for the court to determine the length of time that your deliberations will take. Take the time which you believe to be appropriate to thoroughly and carefully review all of the evidence and other information provided to you. Many of you have cell phones and other electronic communication devices. You are not to bring your cell phone or any other electronic device while you are sequestered. If you do, the court will hold those devices in a secure location until your verdict has been read in open court. You are to reach your verdict based solely on the evidence and the testimony presented to you in this court according to the instructions I have given you. Those of you selected as alternate jurors to serve on this jury panel, you must remain and be sequestered until the jury has returned its verdict in open court. A juror selected as an alternate is not permitted to participate in the jury's deliberations unless one of the deliberating jurors is found by the court to be unable or disqualified to perform his or her duties. You will remain in the visiting judge's jury room and apart from the other jurors and remain under the direction of sworn staff until the verdict is reached. The alternate jurors will not accompany the jury to the jury room or participate in deliberations. The alternate jurors continue to be part of the jury panel while the other jurors are deliberating until you are fully released from this case by the court. You shall not discuss this case with anyone or to each other or tell anyone how you would have voted until you are fully released from this case by the court. Jurors 1 through 12 will now retire to the jury room to deliberate upon your verdict. The bailiff will confer with you regarding any recess or adjournment. And then for tonight, the visiting, or the alternate jurors, this reads, will now return to the visiting judge's jury room, but because it's after 4, Ruth, who's been helping you on all the breaks and who's in charge of the food and all of those things, she will take charge of the 5 alternates and put you somewhere where you can have access to a bathroom and those types of things. Before I read this last paragraph, I just want to talk. So we ordered food, it's going to be here at 5. So what I would suggest is go into the jury room, select your 4-person, and then if you want to eat while deliberating, we'll take you down and get your food, you come back and deliberate. If you want to take an hour break or a half-hour break just to eat and not talk about it, then everybody will go downstairs and eat dinner. So why don't you just go in there, you'll select your 4-person, and then you'll let Ken know what you've decided about dinner, okay? So I want to thank you and express my appreciation as well as that of the parties for your service as jurors today and throughout the last 5 weeks. By providing this service, you have contributed toward continuing the unique system of justice which we enjoy in this country. And so with that, we are adjourned. So also too, you now may take your notes and your jury instructions. The alternates, I want you to leave yours upside down on your seats. We will collect them. If there's a need for you to replace one of the other jurors, then you will have your notes at that time. What did you say?
Yeah, backwards, you take the alternates.
Okay, excellent. All right, we're adjourned. So the 5 alternates just remain. Yes.
Can you walk your first rubber back?
Yes, you may. And then you'll meet her out there in that one. Okay? Yeah. Objections on behalf of the state.
No, Judge.
Mr. Gorman.
Judge, I believe, Mr. Riley, correct me if I'm wrong, our one objection is the language in the jury instructions that allows them to consider 404B evidence for, I think they have identity plan, what's the other one?
Motive and identity and plan, yes.
For all the reasons that we've argued throughout this trial, before this trial, and as the jury instructions were being prepared, we would renew all those discussions.
Yes?
Yes, ma'am.
Okay. So, and for the record, I want to make sure that that objection was preserved. We had talked about it. I just didn't want to do it at sidebar, and so I had preserved that objection outside the hearing of the jury. So that objection is noted and overruled. Anything further? All right. So if you want to wait and just see what they've decided about dinner, if they're going to go eat and not deliberate, or if they're going to get their food and come back and start deliberating.
Okay, yeah, we'll wait for that, Judge, and then if we do leave,
We have
we'll
everyone's
be
cell phone.
downtown, and Mr. Masich, I believe, has both of our cell phone numbers.
Yeah.
Is that fair?
Yes.
Yes.
And then my plan is that, 8 o'clock-ish,